You may have seen a headline saying the Supreme Court just dropped an emergency ruling that could wipe out restrictive carry rules across America. Pause. If you believe that headline without knowing the fine print, you could walk into the wrong place with a gun and end your day in handcuffs. Quick question before we continue. Are you subscribed? Because what I'm about to explain could save you from a life-changing legal mistake. Hit that button right now because gun laws move fast and the people who wait to catch up are usually the ones who get burned. Here's what just happened, and this is the part that shocked me. There is not a final nationwide Supreme Court order saying every restrictive carry rule is dead. That did not happen. What is happening is still a huge deal, but you need the real version, not the internet version. First, remember the 2022 Bruen decision. That was the case where the Supreme Court struck down New York's old proper cause rule. In simple terms, New York used to make regular people prove they had a special need before getting permission to carry in public. The court said no. The Second Amendment protects carrying a handgun for self-defense outside the home, and states cannot make you beg for a special reason first. But here's the crazy part. After Bruen, states like New York, Hawaii, California, and Maryland did not just throw up their hands and quit. They rewrote the map, fast. New York passed the Concealed Carry Improvement Act. Hawaii passed Act 52. California pushed SB 2. Maryland expanded its own list of forbidden places. And instead of saying you can't carry at all, these states said, fine, you can carry, but not here, not there, not over there, not on this property, not near this event, not in this building, and maybe not on most private property unless the owner clearly says yes. That is why people started calling some of these private property rules the vampire rule. Weird name, I know, but the idea is simple. A vampire cannot come in unless invited. Under these laws, a permit holder could not carry onto private property open to the public unless the owner gave express permission. Think stores, think restaurants, think shops you walk into every week without a second thought. Now, this is where it gets interesting. The biggest live Supreme Court case on this issue right now is Woolford v. Lopez. The court agreed to hear it, and the justices heard arguments in January 2026. The main question is whether a state can make it a crime for a licensed concealed carry holder to bring a handgun onto private property open to the public unless the owner gives express authorization. Read that again in plain English. If you have a permit, can the state still say you are a criminal for walking into a regular business while carrying, unless the business clearly invited armed customers? That is the fight. And here's why people are fired up. The answer could affect far more than one state. It could shape what happens in Hawaii, California, Maryland, New York, and anywhere else lawmakers try to turn most public life into a patchwork. But wait, there's something even more important. This is not just about private businesses. It is also about how far states can stretch the idea of a sensitive place. That term means places where gun restrictions may be allowed because of strong historical examples. Bruen mentioned places like courthouses, polling places, and legislative assemblies. Most people hear that and think, okay, schools and courthouses, maybe that makes sense. But some states went much farther. Parks, beaches, museums, libraries, transit, hospitals, bars, restaurants that serve alcohol, even areas near public demonstrations. So the real fight is not just whether you have a permit. The fight is whether your permit means anything once you leave your driveway. And this is where most people get it wrong. They hear a Supreme Court case and assume the law already changed. No, not yet. As of right now, the Woolford case was argued, but the court has not issued its final opinion. That means your state law today is still your state law today. If your state bans carry in certain places and you ignore that because some guy online said the Supreme Court ended it all, you could be the test case nobody wants to be. Imagine this. You have a valid permit, you stop for gas, then you walk into a convenience store, then later you meet your wife at a restaurant, then you pick up medicine, then you go to a public event downtown. In a free state, that may be normal. In a restrictive state, one or more of those stops could create criminal exposure. Same permit, same person, totally different result. That is why this case matters so much. It is not about theory. It is about your normal Tuesday. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. Now let me break this down even further, because here's the part nobody's talking about. There are really 3 battles happening at once. First, there is the permit battle. Can a state demand extra hoops before you get the permit? Bruen already answered part of that. States cannot require a special need like proper cause, but they still try other filters like good moral character, interviews, extra disclosures, and long training requirements. New York's post-Bruen law used a good moral character standard and required lots of personal information. That became part of the fight in Antoniuk versus James. Second, there is the location battle. Even if you get the permit, where can you actually carry? This is where sensitive places comes in. States say these places are dangerous or special, so they can ban guns there. Gun rights challengers say states are abusing that label to make entire cities off limits. Third, there's the history battle. This sounds boring, but it decides everything. After Bruen, courts ask whether a modern gun rule matches America's historical tradition of firearm regulation. In simple terms, did we have similar rules in the past? And if so, were they common enough to count? That sounds clean, but in real life, it gets messy fast. Here's a hypothetical example to explain this. Let's say a state bans carry in parks, libraries, beaches, buses, and every private business unless the owner posts a sign saying guns are welcome. The state then says, well, long ago there were some old laws about certain public gatherings and some property rules, so this is close enough. Gun rights challengers say, no, that is not close enough. You're taking a few old examples and using them to justify a giant modern ban. That exact fight showed up during Supreme Court argument in Wolford. Some justices seemed very skeptical of the state's logic. Chief Justice Roberts pushed on the idea that private property consent rules work like ordinary property law. His point, in simple terms, was powerful. We do not usually need a sign on the sidewalk inviting people in before they can enter ordinary property open to the public. So why would carrying a lawful handgun suddenly flip the rule? Justice Gorsuch raised another issue that got a lot of attention. He questioned why the state relied so heavily on an old 1865 Louisiana Black Code law. And if you know anything about black codes, you know why that matters. Those laws were used after the Civil War to control and suppress newly freed black Americans. So when a state says, look, here's a historical gun restriction, the next question is, yes, but is that the kind of history we should trust? That is a big deal. But here's the twist. Not every justice sounded ready to throw all these rules out. Justice Jackson pointed out that after Bruen, states may have been trying to protect property owners by making clear they can exclude guns. That means at least some members of the court are still wrestling with the balance between your right to carry and a property owner's right to control entry. Now, quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. So, what does that mean for you? It means a big ruling could be coming. It means the court may limit how far states can go, but it also means nobody should act like a final national victory is already here. And don't make this mistake. Do not confuse a challenge to one kind of carry restriction with a total end to all carry restrictions. Even if the challengers win big in Wolford, that would not automatically erase every permit rule, every sensitive place ban, every reciprocity problem, or every local enforcement risk overnight. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who get these updates first. Click subscribe. Let me explain why this matters even more than most people realize. Lower courts are split. That means different federal appeals. Courts are reaching different answers on similar carry rules. And when that happens, the Supreme Court is more likely to step in. For example, New York's carry law has already been through repeated court fights. One version of the Antoniuk case went to the Supreme Court, and the justices sent it back for more review after the Rahimi decision. That remand was important, but it was not a final ruling saying New York's whole system was dead. Later, another attempt to get Supreme Court review of New York's law did not give challengers the clean nationwide answer they wanted. So if someone tells you, the court already ended these laws, that person is skipping major details. Maryland is another state to watch. A federal appeals court there said Maryland's ban on carrying on private property open to the public was unconstitutional, but it upheld many other location bans. That shows you something important. Courts are not moving in one straight line. They're cutting these laws piece by piece. One rule falls, another survives, another gets narrowed, another goes back for more hearings. That is why the next Supreme Court opinion could be explosive. Not because it will magically create permitless carry in all 50 states, it won't, but because it could tell lower courts, in clear language, that states cannot play games by turning normal public life into one giant no-carry zone. Here's the part that scared a lot of viewers when they first heard about this case. They thought, if the court says private businesses cannot be default gun-free zones, does that mean businesses lose control? No, private owners still matter. A business can still tell you to leave. A business can still post signs if state law allows that system. Trespass laws still exist. Property rights still exist. The question is, who gets the default rule? Is the default carry is banned unless invited? Or is the default carry is allowed unless the owner says no? That difference sounds small. It is not small. It changes everyday life. Think about a single mom with a permit who stops at a grocery store after work. Think about a trucker driving across several states. Think about a nurse leaving a late shift and stopping for food. Think about you parking at a gas station at 11 p.m. If the default rule is criminal unless invited, then lawful carry becomes a trap. If the default rule is lawful unless told otherwise, then the permit actually means something. Most people think the biggest gun law danger is buying the wrong gun or crossing a state line with the wrong magazine. But the truth is often much simpler. It is walking into the wrong place. So what should you do right now before the court rules? First thing, learn your state's current carry map, not the one you wish you had. Second, if you travel, check the law for every stop, not just the destination. Third, treat private property rules seriously, especially in states that copied post-Bruen restrictions. Fourth, watch for signs, because even where a broad state default rule gets struck down, posted notice may still matter. Fifth, do not rely on viral videos with dramatic thumbnails and zero paperwork. Sixth, if police contact you, stay calm, keep your hands visible, and follow the law in your state about disclosure. And seventh, remember that a permit is not body armor against prosecution. If the location is off limits under current law, the permit will not save you. This information could literally change the way you carry the next time the Supreme Court speaks. Subscribe now. The next video explains exactly what you need to do the moment that ruling drops. So here's the takeaway. The Supreme Court has not issued a final nationwide order, wiping out restrictive carry rules across America, but it is actively reviewing one of the biggest public carry questions since Bruen, and the answer could reshape how much your carry permit actually protects in daily life. Pause. If you care about your rights, your safety, and staying out of legal trouble, don't wait until a headline confuses you after the fact. Subscribe right now, stay with this channel, and I'll keep breaking this stuff down in plain English so you know what changes, what doesn't, and what you need to do next. And one last simple reminder, laws change, facts matter, and this video is for education only. For advice about your exact situation, talk to a qualified attorney in your state.